Welcome to Clue, Criminal Law for UK Enforcement. Can shouting, swearing, or losing your temper in public get you arrested? Sometimes, yes, but it depends on what you say, how you say it, and who's affected. In this video, we break down public order offences, what the law says, and what the police look for. We will answer the question, can I be arrested for swearing at a police officer? Stick around to find out where the law really stands. Let's start by answering the question, what is a public order offence? Public order offences cover behaviour that is threatening, abusive, insulting, or likely to cause harassment, alarm, or distress. It is also behaviour that's meant to provoke violence or disrupt public order. To count as an offence, this must take place in public. Public Order Act 1986, the main law that deals with how people behave in public spaces and what police can do when things get out of control. This act covers a wide range of public order offences, starting from low-level disorder, like swearing or shouting in public, all the way up to the most serious offences, like riots and group violence. Let's look at the most common offences under the Public Order Act 1986, each with its own legal test and consequences. Riot, Section 1. Violent disorder, Section 2. Affray, Section 3. Threatening behaviour, Section 4. Disorderly conduct, Sections 4A and 5. For easy memory, remember, Sections 1 to 3 involve violence. Sections 4 to 5 cover abusive words or behaviour. Section 5. Harassment, alarm, distress, the lowest level. Under Section 5, it's an offence to use threatening, abusive, or insulting words or behaviour that could cause someone harassment, alarm, or distress. You don't need to target someone directly, and you don't need intent. This covers low-level swearing or public arguments that upset others. Section 4A, intentional harassment, alarm, distress. Section 4A is more serious. It's illegal to use threatening, abusive, or insulting words or behavior with intent to cause someone harassment, alarm, or distress. This means you meant to upset or scare them, not just that they happened to feel that way. The difference in this case is the person's intent to cause harassment, alarm, or distress. Section 4. Fear or provocation of violence. Under Section 4, it's an offence to use threatening behaviour or words that cause someone to fear immediate violence. It's not about hurt feelings, it's about making someone think they're about to be harmed. This is often used when arguments or confrontations get physical or threatening. So, what are the key differences between Section 5, 4A, and 4? The difference comes down to Section 5, cause distress, no intent needed. Section 4A, intended to cause distress. Section 4, threats of actual violence. The more serious the words and impact, the higher the offence and the tougher the penalty. Next, let's look at Sections 1, 2, and 3, the most serious public order offences. Under Section 3 of the Public Order Act, it's an offence to use or threaten unlawful violence in a way that would make a reasonable person fear for their safety. Affray can happen even if no one else is actually present. It's about how the behaviour would be seen. Example, two people fighting aggressively in a busy street causing bystanders to panic and flee. A conviction carries serious penalties. Section 2. Violent disorder. Under Section 2 of the Public Order Act, violent disorder happens when 3 or more people use or threaten unlawful violence, and their behaviour would make a reasonable person fear for their safety. Actual violence doesn't have to happen. The threat alone is enough. This is a serious offence. A conviction can lead to prison. Section 1. Riot, the most serious offence. Under Section 1 of the Public Order Act 1986, a riot happens when 12 or more people use or threaten unlawful violence for a shared purpose, causing fear for safety. A real example, would be the 2011 London riots, where groups caused damage, looting, and public fear. Riots are rare, but if convicted, carry serious prison sentences. So, what are the key differences? Sections 1, 2, and 3. The key difference is numbers and seriousness. Section 3, affray, needs one or more persons to using or threaten violence, causing others to fear for safety. Section 2, violent disorder, 3 or more people threatening or using violence. Section 1, riot, 12 plus people using or threatening violence together. The more people and harm, the higher the offense. So, remember words versus violence. What's the difference? Sections 5, 4A, and 4 deal with words, threats, or abusive behavior. They're less serious and usually involve fines or community orders. Sections 3, 2, and 1 involve actual violence or threatened violence. This comes with harsher penalties and possible prison. The more violence and fear caused, the more serious the offense becomes. Now that we have that covered, let's speak about racially or religiously aggravated offenses, when hatred makes it worse. If a public order offense is motivated by race or religion, it becomes aggravated under the Crime and Disorder Act 1998. This includes racist or religious insults, abuse, or threats. The law treats these offenses more seriously, with tougher penalties, fines, and prison time. This also goes for homophobic and transphobic public order offenses. If abusive words or behavior target someone's sexual orientation or gender identity, it can turn a public order offense into a hate crime. Homophobic or transphobic abuse, whether spoken, written, or through gestures, is treated more seriously by the courts, with harsher penalties including fines or prison. Case law, DPP v. Oram, 1988. Swearing at police. Is it an offense? In DPP v. Oram, 1988, a man repeatedly swore at police officers in public. The court ruled that while police must tolerate some abuse, if the words are likely to cause harassment, alarm, or distress to members of the public, it can still be a Section 5 public order offense. It's about the impact on others, not just the officer. Recap. Public order is behavior that disrupts public peace, safety, or causes fear or distress. These fall under two groups, Sections 5, 4A, and 4. Words, threats, or behavior causing distress, less serious, often fines. And Sections 3, 2, and 1, violence or threats of violence, more serious with possible prison. If the offense involves race, religion, sexuality, or gender identity, penalties are tougher. If this helped, give it a like and hit the subscribe button. Stay tuned for more videos. Keep learning, keep overstanding. Know the law, understand the offense. See you next time. Thanks for watching. If there's a legal topic you'd like us to break down, drop a line in the comment section below. We're here to make the law clear, practical, and easy to understand.